Hi, my name is Muhammad Haikal, and now we focus on my slide. For element 3, we focus on interference disposition. The key rule here is that the plaintiff might have actual physical control of the property, along with the intention to exercise that control at the time the interference occurs. This means that even if someone is the legal owner, they cannot sue unless they are in possession of the property. In contrast, a non-owner who has possession can bring a claim. This principle is illustrated in the case of Painful Winds versus Elias, 1946. In this case, although Painful owned the bottles, they did not have immediate possession because the goods were in the hand of a bailee. The court held that without actual possession at the time of interference, Painful could not succeed in their claim. So the takeaway is possession, not ownership, is the key requirement in this element. Next, we move to element 4, which is actionable per se. This means that the law protects possessory right as something valuable on its own. In cases of trespass, the plaintiff is not required to prove actual financial loss or physical damage, as long as there is a direct and intentional interference. That alone is sufficient to establish liability. Even if no real damage is suffered, the plaintiff can still claim nominal damage, which symbolically recognizes that their rights have been violated. So essential, the law says the act itself is enough even without proof of harm. This slide shows a practical roadmap for handling cases involving movable property. First, we identify whether there is an incident involving movable property. Next, we ask, did the plaintiff have physical possession? If yes, we can proceed to assess possible claims such as conversion or negligence. Then we consider whether there is physical harm or actual loss. If there is actual damage, the plaintiff can sue for actual damage. If there is no damage, the plaintiff can still sue for nominal damage under actionable per se. Finally, in terms of remedies, the plaintiff may enforce their right under the Specific Relief Act 1915 or claim damage within the 6-year limitation period. So this roadmap helps practitioners decide the correct legal action step by step.
Hi, good day everyone. Today I will be presenting on trespass to personal property under tort law, focusing on three key cases: Litang and Cooper, Click and Gregoria, and Penfold, Wise and Elliot. And that each one tells us about how the law protects a person's possessory rights. Starting with Litang and Cooper in 1965, the claimant was sunbathing in a car park when the defendant accidentally dropped over her legs. Because her negligence claim had expired, she tried to sue in trespass to the person instead. The court rejected this, holding that unintentional act must be dealt with under negligence, not trespass. This is important because it confirms that trespass requires an intentional act. Moving to Kick and Gregory in 1876, the defendants moved the deceased jewelry to another room without permission, believing it would be stolen. Some jewelry later disappeared. The court found her liable for trespass to goods. Her good intention was irrelevant. This case shows that direct interference with another goods without authority is trespass, regardless of motive. Penfold, Wise and Elliot in 1946, the defendants refilled branded bottles belonging to Penfolds and tried to resell them. The High Court of Australia clarified that to succeed in trespass to goods, the plaintiff must show actual possession at the time of interference. Ownership alone is not enough. These three cases together define the boundary of trespass to personal property. The key elements are an intentional act, a direct interference, and possession by the plaintiff at the time. In Malaysia, these English common law principles are received under the Civil Law Act 1956, making trespass to personal property a vital and relevant area of our legal system today. To conclude, this presentation was built upon a comprehensive review of legal authorities and academic literature. As we can see on this final slide, our research drew from a diverse range of 15 primary academic sources, which include 3 foundational textbooks and 2 specialized book chapters covering the law of tort and property rights. 8 peer-reviewed journal articles that provided contemporary insights into Malaysian law, digital assets, and environmental negligence. We also rely on the Civil Law Act 1956 and specific institutional research to ground our findings in the Malaysian legal framework. Our arguments were supported by 3 landmark cases: Litang and Cooper, Cake and Gregory, Penfolds wine, which remain pivotal in understanding the boundaries of trespass and charter. Thank you very much for your attention and time. This is all of our team presentation. Thank you and goodbye.